Granger.
Okay, you're aware he was beaten up by Brian Cobb Albert. I mean, we're all in on the same joke, right? My tail light is cracked and jaw was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay?
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record. Okay, how is everybody? Here we go. Wanted to talk today about Karen Reed's hearing yesterday, and is the defense turning the court into a kangaroo court with the help of Judge Cannoni? That was what was on my mind after yesterday. Judge Cannoni already ruled terribly, in my opinion, in letting a attention-seeking true crime fan cosplay as an expert witness in this case. Marie Russell, of course, I'm talking about. But will she let Richard Green, who we've now learned is a criminal, will we let Richard Green testify on his debunked opinions? That was actually the name of the filing. Richard Green's debunked opinions. Now, if you haven't seen the stuff on Richard Green, and if you haven't seen his mugshot, this stuff, it's like what I wrote about it on Twitter was like, this is very much the Karen Reed innocence fraud campaign is very much a criminal supporting other criminals kind of thing. Enterprise. Let's put it that way. Enterprise. Here's Richard Green. Here's his mugshot. Looking quite different than the Richard Green. I'm going to call him McNasty. Because he was at McNasty's bar. It sounds like I make this stuff up, doesn't it? McNasty's bar. If you're spending time at McNasty's bar, maybe you want to rethink your life and your decisions. McNasty Green. Hold on, let me share my screen so I can show you. This is like unreal. Wait, hold on one second. Let me just get myself in order here. My apologies for making you wait. Okay, here we go. I'm in order now. I was so frantic, upset that I was making my audience wait, that I didn't get my bookmarks in order, but I want to show you. I have a bunch of stuff to show you, but this comes from Julie Carpenter here. So this is all about Green. On the above listed date, this is from the cop, I responded to, this is concerning Mr. Green, McNasty Green. I responded to the listed address in reference to a battery. The call notes stated that the complainant, Richard Green, had been thrown to the ground at McNasty's bar. Upon arrival, I observed a white male to be sitting on the ground. Upon approaching the individual, he identified himself to be Richard N. Green. Richard advised me that he had been assaulted inside the bar. When I questioned what happened, he stated originally that Robert had twisted his arm and then thrown him forcefully to the ground. When I asked him to elaborate more, Richard then changed the story to say Gabe threw him to the ground. And then I asked him why Gabe would do that, and Richard had no answer. When I questioned Richard if he was hurt, he started to say his left elbow was hurt and both of his knees were sore. Richard continues to say that he has both knees surgically replaced. Richard was adamant about his story and kept insisting that the bar not delete any video of the incident they may have. While Richard was sitting on the ground, I could smell the distinct odor of alcohol emanating off of his breath from several feet away, and Richard's speech was slurred. When Richard was stating his injuries, I observed a small hematoma on the outside of his left elbow. However, I did not see any physical marks or to his skin or knees. Due to Richard's complaining about his elbow hurting, he requested that I contact paramedics and have them come to the scene. While paramedics were treating Richard, I went into the bar to talk with the possible witnesses. I was confronted by James Frumfield. As I entered the bar, James advised he had seen what had happened as he was sitting at the bar by Richard. James stated Richard had been drinking a lot and harassing the bartender. James stated he saw Richard grab Trisha's arm as she was walking by and say something to her that upset her while holding her. Saw Richard come over and help Trisha get away by grabbing his wrists. James then said Trisha left the bar and came back inside a couple minutes later. Shortly after Trisha returned inside, her husband Gabe came over and approached Richard from behind. James stated he saw Gabe place his hands on Richard's shoulders lightly and leaned in to talk with him. Shortly after Gabe talked with Richard, Richard got up, then stumbled before falling over onto the ground. Okay, so that's what happened. He was harassing the female bartender, and then he fell to the ground and accused two people. And then so he had to enter into a plea deal with the court to avoid a court case. So you can see the intervention here. It's in the show notes. If you want to see it, look at it yourself. But that's what happened there. I mean, you just can't make this stuff up. So I wanted to show you some of the hearing and share my thoughts. First started with Gretchen Voss, who attended the hearing. She's the Boston Magazine article, journalist who wrote the first article about Karen Read that really sparked the innocence. I mean, really sparked off the innocence fraud campaign. It was told totally from Karen Read's perspective. And that's still the narrative that both sides of the fence use when they talk about this case, the Gretchen Voss narrative. So she was in attendance. She's still trying to get her notes not shown in court. I don't really care about her notes. The most important thing to me, which she also fought, was the unredacted tapes. And she redacted, I think it was an hour and 50 minutes from those tapes. It's crazy. There was more redaction than there was actual tape. There was two interviews. And so the fact that we have these unredacted tapes of the interview, I think, are going to be very compelling evidence in court against Karen Read. I don't care so much about Gretchen Note's perceptions of Karen Read. If there's, and neither does Judge Cannoni, and she made that clear, but take a look. So she originally goes round and tries to kind of, you'll see she moves.
Has anybody checked to make sure the mics are not on at our table with the TV people?
This is the funniest part of the hearing for me. Robert Alessi, Karen Reed's innocence fraud lawyer, her pro bono, attention-seeking, clout-seeking lawyer, is worried about the mics. Should we hear that again? I'd like to hear it again. It makes me laugh every time. So let's just go back just a little bit.
For this morning,
What?
that we want to.
Sorry, let me go back. So in the beginning. Kitty's 1993. Thanks for being a member for 7 months. Definitely seems like Green has more than a few skeletons, right? Those are the ones we found so far. Here's Robert Alessi.
Has anybody checked to make sure the mics are not on at our table with the TV people?
Just a reminder, folks, about cell phones, please make sure that.
So then Alan Jackson's like, look, this is how the pros do it. You can mute your mic here. That's what it looks like he's doing to me. But they're on all the time. If you want to mute them, go over there. Walk away from them if you don't want to be picked up. But they're on. Once court is on, they're on. Karen Reed looks not amused. I thought this was hilarious. And then they start looking under the tables and stuff. I mean, is this high comedy? Who could have thought of this? Who could have thought of this?
Silent mode, please. All cell phones, please.
That boss?
It's under the table, actually.
Yeah, I can't see it.
That's okay. Thank you.
So then he goes to talk to Yannetti far away from the mics. Whatever they're talking about. Whatever he wants to talk about, he does not want us to hear. So they go over there and have a little conference right before court starts. And now I just kind of sped this part up. And then Judge Cannoni comes in and we're ready
this
to
morning,
begin.
That I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning.
Oh, this is interesting. It looks like they didn't file correctly. Is that right here? They sent in 2 different affidavits from Richard Green.
Motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Birchie.
Good morning, Your Honor. Rob Birchie for Gretchen Voss.
So I just moved forward in his argument because it's the same argument we've heard from him. He uses precedent. There is no precedent there is no law, okay, in Massachusetts to protect sources and journalists from giving over their notes and the recordings that they've made. So of course she had to hand over her note. There wasn't anywhere for Canoni to go, although she did exclude them last time, which I thought, again, I didn't really understand, but okay. There's really no, I guess she's correcting her own legal errors here. If you want them, you should be able to get them. So she got them, and they're still trying to protect the notes, and they've handed them over. And what Canoni says is like, look, I'm only interested in what Karen Reed told Gretchen Voss. So what her lawyer makes out the argument that this will uses things like the Pentagon Papers and Nixon and the whole history of journalism. Like if we couldn't protect Deep Throat, Nixon would have never been impeached, etc. The whole history. This is not a Nixon situation. The only person who can be hurt by handing over Gretchen Voss's unedited tapes is Karen Reed, who's an accused murderer. What are we talking about here? This is not of interest to the whole of the world. Whether Karen Reed gets convicted or not will only influence whether we're going to see more innocence fraud campaigns pre-trial like this. And already they're referencing this trial in other Massachusetts cases. So we've gotten our answer to that. But as of all of journalism and all of our entire world being affected, whether these notes are public, is absurd. Gretchen Voss, the only reason we know Gretchen Voss's name, is because of the Karen Reed case. So to say she didn't benefit from this, so spare me, Gretchen Voss, your argument that you've been harassed so much. I'm harassed every day of my life that I report on this. Pretty much every day, someone saying something negative about me, to me, slandering my name, accusing me of all sorts of things, telling me I'm terrible. It's par for the course. Toughen up.
All right, Aponte. Geri, all persons having business before the Honorable Penni County, just to the Norfolk City County of Norfolk. Your Honor, give your attendance and shall be heard. I say in Commonwealth, Massachusetts. School is now open. You may be seated.
Judges 22117 Commonwealth versus Karen Reed. Can I have counsel identify themselves as starting to Commonwealth?
Good morning, Mr. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for Commonwealth.
Good morning, Mr. Brennan.
Good morning, Donnell Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Leslie on behalf of Ms. Reed.
Good morning, Mr. Leslie.
And good morning, Your Honor. David Yanetti for Karen Reed.
Good morning, Mr. Yanetti. Good morning, Ms. Reed. The non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo.
Again, in the limelight and triggering a new round of harassment. Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that shows that she was dedicated to covering the trial, come what may. She tells me she has in the recent past.
Right, but she has certainly Boston Magazine or some outlet would give her a journalist to sit in her place and take notes during the trial. She could watch them from home. There is no reason she had to attend the trial if she's in fear for her life. She wants color commentary on what happens in court. Send someone in her place to take notes. There's no reason. I made the same argument. Why was she in court if she was so in fear for her life? If she's so in fear for her life, why is she joking with Turtle Boy that she's going to go the Jersey girl in her wanted to basically go to Fist City with friends of John O'Keefe and the O'Keefe family for giving her daggers, because they know that she's the one who started this whole innocence fraud narrative. It started with her. Karen Reed was so upset. Karen Reed was so jealous. Karen Reed was so drunk she may not have known what she did. All that started with Gretchen Voss's piece. This is the beginning of it. So spare me that I'm not so sympathetic, Gretchen Voss, that you've been harassed. And I'm skeptical of these harassment claims. Because certainly Aiden Turtleboy Carney had no issue yucking it up with you in court. And I've gone over those text messages between them over, I think, twice or three times. Do you want to see them? I'll show you them again.
Gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
I do have one point to make to you.
I have one point to make, too, about Gretchen Voss. And thankfully, it's in Innocence Fraud Watch's blog. Here they are. Gretchen Voss decided to get ratchet with me today. This is Aidan Carney writing on X. In the media line, here's what she really thinks of the O'Keefe family and the Dugals, who are friends of John O'Keefe's. But that was before David Traub got to her with his burger. Yep, the Jersey in me was this close to asking Carl Dougal. He's the one in the beginning. I changed it up today just because I was getting bored with my opening. But my usual opening has Carl Dougal asking, or what's alleged to be Carl Dougal, asking Karen Reed, why'd you admit to it? She did. She admitted to it like 3 or 4 times. I love that. So that's Carl Dougal, Carl's wife, who spent the entire hearing staring at me and rolling her eyes with this disgusting smirk on her face to take it outside. She wasn't so tough with you after. Nice work, all between us. So if you ask, and that's just like a little of the back and forth between the two. So she complains about Peggy O'Keefe in that as well. So these journalists are a big part of furthering the narrative. And here's a great quote from John Collins, who I interviewed, who also wrote a book called The Crime Lab Report, which is like the only book really about innocence fraud. It's an academic book. A common thread in many exonerations is the use of willing journalists to front load a post-conviction investigation. This is a pre-conviction investigation with the construction of a compelling innocence narrative. Indeed, this can be a problem in typical criminal investigation where the press jumps to a conclusion about a suspect's guilt. But in post-conviction litigation, the passage of time makes it much easier to sell the alternative story as being legitimate. But in this case, nobody knew the compelling story. So it was easy to sell the alternative story when nobody had a grip on the facts.
Mr. Burt,
So here Judge Cannone is going to say what she's really interested in is Karen Reed's statements, not so much Gretchen Voss's perception.
The amicus brief, or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall.
So in camera means secret, not recorded. In private, off camera. Kind of an Orwellian name.
Story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant. Work on that, I'd appreciate that. Sure. So I will take the lead from the two of you on that.
Thank you.
Okay. All right, so this brings us to the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So I have received...
Literally, these opinions have been debunked, proven wrong. The program had to totally, Cellbrite program had to totally rewrite their program so these kind of errors in reading the data wouldn't occur again. And the defense is like, well, that's just an opinion. It's not an opinion. They had to rewrite the program. It's not it's in the opinion of the program that did the software that it's wrong. And they're like, well, there's all this other software, including Axiom, which Ian Whiffen, who was a witness for the Commonwealth, wrote himself in his room. He's the author of Axiom software. So I would tend to think that he would agree if his software brings up the same kind of errors, that it was an error in reading it. So what this means is if you open up, say, if you look at, say, 2:27 a.m., you look up something on a tab and you leave it open, and then you use that same tab at, say, 6:23 and 6:24 to search for how long to die in the cold, the old Celebrate software would time date that at 2:27, the time you open the tab, not the time when there was, you were actually searching. So it's just going to confuse the jury about the actual software if she lets him testify. But I'm sure that the Commonwealth can ram that home through their heads. It's just you don't want to have one confused juror. We've already had a hung jury already with what is actually, what is, how the software works and what it says and what it means.
A great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance, so I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of "how long to die in the cold" at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially is scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology.
Right. But what he goes on to say here was more interesting to me. And this is, of course, Hank Brennan for the Commonwealth. For those of you who are just tuning in, we're watching Karen Reed's latest hearing that occurred Friday. What was more interesting to me about what Hank Brennan said was that once again, we have another witness, another defense witness who has drastically changed their style of writing and opinions from the first trial to the second trial. What's different? Robert Alessi. What did Marie Russell testify to on the stand that Robert Alessi helped her with her report? Just putting in some things in a few places. Strangely, her opinion had totally changed and gotten more certain. Strangely, her opinion has gotten more and more certain over time as Robert Alessi has become involved and more elaborate. And this is what I mean about making the court a kangaroo court. We have this attention-seeking, clout-seeking, innocent fraud lawyer, Robert Alessi, in there trying to get clout for himself, putting words in the witness's mouth. Apparently, Richard Green has also changed his statements about where he's qualified So how come, Julie Carpenter asks on X, how come Richard Green's sworn affidavits don't match the sworn testimony about his CGE certification? Green testified after swearing an oath to tell the truth that the International Association of Criminal Investigation Specialists was a certifying body. In his affidavits, he swears under the pain of perjury that his certification came from the International Association of Computer Forensic Examiners. Spoiler alert, neither organization exists. The naming convention for both is similar to legitimate organizations, though.
Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Recharacterizing the simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9. He talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy and insinuations and surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very...
Your Honor, we're confused because first he signs his first affidavit, Richard Green, and then he signs it McNasty Green. Can you shed any light on this?
dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data, or we don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common approach reviewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government is going to take to this case. If Mr. Green is going to testify, he should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there is some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that may come at some point. But the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing
Just so the science and data is clear, let's look at McNasty Green's place of work very quickly. I can do it quickly. Let's see. That's where he works. That'll give you an idea. He's in the next to the great establishments, next like Tattoos, PJ's Party Room, PJ's Seafood and Restaurant. That's where his offices are. McNasty Greens. Just to give you guys an idea.
Or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the defense touts, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that he reviews the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then it has a last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to. And this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if iCloud Safari synchronization is enabled across multiple devices on one iCloud account. And so, by axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open, it is open at a particular time. And if that tab is reused, the original time will imprint. And so, certainly Mr. Dilley knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde, because he takes shots at them or makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side.
Right. And if you read their defense's report, it's like, strangely, Jessica Hyde changed her opinion. Strangely, mysteriously, she changed her opinion. And she explained on the stand. It wasn't strange. It wasn't mysterious at all. She explained on the stand exactly why it's erroneous. And this is what you want from an expert. You want them to be an expert in their field and not an advocate and not a hired gun for the defense. And that's how Marie Russell comes across. That's how McNasty Green comes across. And that's why I say their best experts are their ARCA experts. But they looked at limited data. We'll get it. We'll get to them. We'll get to them. Free Karen readers, we'll get to the ARCA experts, I promise. But these guys are hired guns for the defense. And you can see the quality of who they are as people. What expert has to read an article and advocate and get themselves in a high-profile trial? This is similarly Robert Alessi. What really good lawyer has to get themselves work pro bono to get attention for themselves, to get some more do-re-mi, because he's looking for some more killers to represent. He hasn't represented any killers. He's in a more boring field, but he wants to be where the real action is with the killers on TV. He hasn't figured out exactly how the recording system works, but he'll eventually he'll get a hang of it. Get slick. He's a little awkward now.
When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in this.
You know, I have no idea what Jessica Hyde's or Ian Whiffen's opinion is about Karen Reed, but I know they know what their opinion is on the tools of their profession. Richard Green had to admit on the stand they had to rewrite the entire program because of his error. in reading the data.
Hyde and Mr. Whiffin's report in this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 2:27. The only effort.
Thank you, Dean Walker, for the super sticker. I appreciate it. Really nice to see you. Really appreciate the super chats on these smaller episodes. I just think this is such an important case to talk about what I think will become a trend. If this succeeds, even if it doesn't succeed, I think it will be copied. And what we'll get is more witness harassment, more harassment of victims' families pre-trial. And this innocence fraud tsunami will just keep sweeping through America and really the world. But I know a few innocence fraud cases abroad, but really where my expertise, if I have one, lies is in the innocence fraud cases in the U.S. Looked at so many of these. And it goes back over 100 years. We just love this story. We love the story of the wrongfully accused. And it doesn't matter how improbable their defense is. One defense is more ridiculous than the next.
That appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffin and Mr. Green. But a simple understanding of the data science is that the wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16, when almost everybody universally agrees who's looked at this phone that there were 2. And so there's no surprise that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number 1 doesn't have any resonance. There's no methodology to support number 1. So of course the fallback is somebody did something somewhere somehow. Not an uncommon refrain that we hear. And so what the claim or the opinion number 2 the defense would like the jury to hear is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit...
Right. They're bringing in things like that the police manipulated the phone. And then when Alessi gets on the stand, it's not Richard Green's problem. It's Trooper Garino. Throw Trooper Garino under the bus. You know, I don't have an issue with defense attorneys in general as a job. Everybody deserves a vigorous defense. But as I had Julius Jones's attorney, David McKenzie, on, what he said is he was appalled by these Innocence Project lawyers. He said, you just can't lie, cheat, and steal. You can cross-examine, you can put on a vigorous defense, you can try to create doubt with the evidence that you have, but you can't lie, cheat, and steal. And that's becoming the fashion of the day for these defense attorneys. Lie, cheat, or steal. Blame Trooper Garino. Blame anyone else. As long as Karen Reed walks and doesn't have to take responsibility for her actions. Purposefully clipping John O'Keefe going 24 miles an hour in reverse with her foot 75% down on the gas pedal, never once touching the brake, with her infotainment system beeping and flashing at her. So excuse us, free Karen Reed people. She hit something that day. And her car data's coming out, free Karen Reed people. Get ready for your latest lie. Because when Karen Reed is caught with Alan Jackson canoodling, oh no, it's made up. It's a manipulated photo thanks to microdots. He can convince all the free Karen readers this has been made up. They aren't having an affair. Well, there's another photo of them getting awfully cozy having drinks after work. Is that made up too? Who would want to make up a photo? So everyone's so against Karen Reed that they want to manufacture all this evidence. Blame the college professor because that's who you want to railroad in a case. Come on. It's so stupid.
Under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2,
the guy is wrong. He's wrong. He had to admit on the stand he was wrong, and they had to change the whole program because he was wrong. So that everyone would understand if they ever analyzed the data the way McNasty Green did, they would be wrong. What are we talking about here? And the fact is that this will probably be let in. Judge Cannoni will probably let it in because she's going to think, well, Karen Reed, she's got her rights. She's got a right to a defense. She's got a right to a defense. Get someone qualified using updated software that this is the right opinion, not old, outdated software. And all this does is set us up for another hung jury. Because one jury will sit there and go, well, what about that 227 search that didn't happen, that Jen McCabe did? Oh. And I was pleased to see that Brennan brings up the fact that Karen Reed was asking at the scene that morning, how long did it take him to die in the cold? Questions exactly like what she asked Jen McCabe to do for her. Look up on the computer or Google how long to die in the cold. It's not because I think that Karen Reed was concerned about John O'Keefe suffering. I think she wanted to know how long he suffered for, and she was hoping it was a long time. Her hatred for John O'Keefe could not be any more clear. You'd have to be blind not to see it.
This expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. An extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good.
Kathy Berea says, what about Donna Adelson paying off 2 inmates who she's currently housed with? These people with money think that they can buy their way out of murder. True. I'll be talking about that probably tomorrow. Or I don't know, about maybe Monday or Tuesday. I don't know. Something. I usually take Monday off, but maybe not this Monday. We'll see.
Great basis to make this assertion. Why is he? It is because The claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts to back it up. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it didn't happen.
Not being able to prove user manipulation because it didn't happen. Trooper, watch Alessi. Then Alessi's like, screams and shouts in the court. Trooper Carino got it wrong. Trooper Carino. It was just a sad and sorry display. And as soon as Hank Brennan is done, or somewhere in this hearing, Alessi mouths to Brennan, good job. I mean, he's like a fan. We have these like fangirls in the court, whether it's Marie Russell, who's like a true crime fan, Robert Alessi offering his services for a bit of the spotlight, worrying about the microphones picking up their secret strategies. It's ridiculous. It really is getting to be a kangaroo court made by the defense. And should she get convicted, it's the defense is going to be arguing it was a kangaroo court. That's the way it's going to go.
He turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes they match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, and the phone and determine whether manipulation occurred.
Did you guys hear that? There's ways that a real forensic examiner can look at the phone and discover ways that it's been a real forensic examiner, not McNasty Green and his attention-seeking lawyer. Did you guys get that? Oh, hey, Buddy Buchanan. Thank you. Thank you, Roberta, for revealing the truth. Justice for John O'Keefe. I hope the closest justice as we have. Real justice would be bringing him, having him here with us.
There's a program called XMP and another one called Magic. The Commonwealth's expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. And
Exactly. And for clarity, like I've said, it's just, he's already been proved wrong. A better person would excuse themselves and say, sorry, I can't take any money because I can't stand behind this. Now that the program has changed their software, I can't testify truthfully under oath. But as we know, Richard McNasty Green doesn't have an issue with lying, as we've seen by him taking a plea deal, accusing people while he's drunk of pushing him to the floor and hurting his knees. Then later on, he says he's having a heart attack. I mean, the whole thing's crazy. I encourage you to read the whole thing. Maybe I'll go back and read the rest of it.
an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in that.
So, just spoiler alert, it doesn't sound like we're going to have a hearing. So I think she's letting him, in. That's my thought. She's not letting him in. I don't think she should let him in, but I think she will. Because if you're going to let Marie Russell in, who's totally, wholly unqualified and has zero methodology, then why not let McNasty Green in? And it was curious to me that Alessi's first argument was that Richard Green had already testified in the previous trial. So he appealed to what I think is the issue here, which is Cannone's ego. She doesn't want to admit that she had unqualified people testify at the first trial. And I also wonder if she is worried about coming under fire from the Free Karen Read people who used to call her biased and give her all sorts of nicknames and throw real hate at her. You have to be really strong to withstand these kind of, they come at you with like pitchforky mob is the only way I can describe it.
Methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There's no other alternative support for his opinions. They're just broad, baseless claims. Number 3, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known or potential rate of error. Well, if we see and read Ms. Hyde and Mr. Whiffen's report.
Right. So he's going over the qualifications for an expert. If it's an error, they can't testify to an error, something factually untrue. It's not an opinion. And then Alessi comes up and screams that it's an opinion. It's a difference of opinion. It's what they do in every single court case in America. No, it's not. If you had a flat earther, sure, the fact that the earth is flat is an opinion. And you have an expert saying the earth is round. Sure, that's a difference in opinion. But one has more science and validity behind it than the next. What are we doing here? Are we going back to flat earth thinking? I feel like we are. When that took off, when the whole flat earth movement took off, I really thought that we're in idiocracy world.
It's not just a high level of error, it's gross error, it's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol.
I don't know. My friend keeps telling me I'm wrong and that Richard Green, she doesn't think Richard Green's coming in. But once I saw Marie Russell, I don't know if I'm just have such a bad reaction to Marie Russell coming in this case. And I thought she got absolutely demolished in her hearings, really. It's a two-parter. So forgive me for thinking that if Marie Russell is qualified, then McNasty Green is qualified, and let's pick Joe Blow off the corner. I know. Like I said, I'm now an expert witnesses in cats. I have decades of hands-on feline experience. I am up as a expert witness for $600 an hour to anyone who wants to pay me. I mean, if this is the standard in Massachusetts for experts, why not get the hobo on the corner as an expert? I mean, if this is all about opinions and not methodology and not fact and not things that you can test, if you're not testing out your theories, then let's get free Karen Readers on the stand to testify for Karen Reed. They all have an opinion that this was at 227.
Does not follow.
And by the way, I noticed Alessi using a lot of the free Karen Readers opinions that had been banded about X. They get ideas from everywhere, these lawyers.
Axiom or the guidance that they give him, he sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, the positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel or an attempted vessel for the defense, third-party culprit defense. It is not lost on me, I'm not unmindful of the data on the phone being a search how long Diane Cole that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive the cold.
Here you go. He's talking about Karen Reed. Why was Karen Reed asking about the first responders on the scene at that morning? Was it the first responders? She's asking that morning People, how long did it take him to die in the cold? What a coinky dink. You know who wasn't asking that question? Jen McCabe. The only one asking that question was Karen Reed. But the way Karen Reed does everything is by proxy. She committed murder by proxy with her car so she could say it was an accident. She got John O'Keefe's niece to call Jen McCabe so she didn't have to call her, so she could make that call by proxy. She always needs a bit of plausible deniability so she can, like as the snake she is, change her story. And she's changed it so many times. And it doesn't matter for the free Karen readers how many times she's changed her story, how many times she's got caught in a lie. They want her to get away with this crime for whatever reason. Hatred towards the police, hatred towards the system. A lot of them that have got caught up in it, committing their own crimes. And a lot of them are just good, gullible people who got duped. There's a sucker born every minute.
Under the extraordinary broadness of circumstances, in the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance. That there is a inquiry, something forming in the mind of the accused is then shared with the witness, Miss McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be a witness in front of the jury, in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a landing and hearing. We are not shying from our burden. We're more than happy to bring in a witness.
Right. So for those of you who are saying that, well, this doesn't matter because Hank Brennan will destroy McNasty Green in court. But really, he shouldn't have to. He's not there to prove the case of how Cellbrite works or not. He's there to prove the case against Karen Reed. So he shouldn't have to do this. This is just an error in reading the data that he shouldn't have to deal with. But unfortunately, I think he will. Emily Suzanne says, Karen Reed, she definitely uses people. Yeah. And look at how she uses and discards people, like the narcissistic psychopath that she is. So when John O'Keefe said he was out of this relationship, which I believe was the end, after she floated out the idea that she had a plumber over, Richie the plumber. Are we going to hear about Richie the plumber? That's what I want to know, Hank Brennan. What about those Richie the plumber text messages? Are they coming in this time? Because they really should. Because John O'Keefe told his friend that night, John Camerano, boy, do I mess up names, that he was angry that Karen Reed had floated out the idea of the plumber to him. And why wasn't she using him to fix her plumbing? Because his dad, Papa, is a plumber. Would have fixed it for free. Why am I waiting for her to deal with her plumbing issues, her hot water issues that night? I hope he's good looking. He's writing to her. I don't think any Richie the plumber existed. I think Karen Reed's plumber, he may exist, but the whole interaction that night with her and the plumber, Richie the plumber, he may actually be a real plumber, but was he over fixing her hot water that night? I think it's a figment of her imagination, just like the entire Karen Reed defenses and fantastical story of the McAlberts is a figment of Karen Reed's imagination. So she discarded John O'Keefe when he was no longer useful to her, like they do in the cycle of narcissistic abuse. And when Kaylee and Patrick, John O'Keefe's niece and nephew, were no longer useful, oh, I want to go back to the house and comfort Kaylee and Patrick. Never said a word to them. Got her stuff and shuffled out in shame. Never ever to talk to the O'Keefe family again. So to the people that watch my Adelson coverage and think like you're so out of it on Karen Reed, this is exactly the behavior you were so critical of unindicted co-conspirator Wendy Adelson doing, never talking to the Markell family again, changing her kids' names. It's exactly the same. So for Karen Reed, it was no longer useful to be cosplaying stepmom with John O'Keefe. She had nothing to say even after this terrible, traumatizing murder that she did. She had not one word of consolation to Kaylee or Patrick. And I think Free Karen readers need their head examined for supporting this person who, even if you don't believe she's responsible for this, you have to recognize that anyone who would spearhead a witness harassment campaign and a campaign of harassment against the victim's family, or if you don't believe she spearheaded it, even though there's evidence to support that she never called off the dogs and said, hey, wait, I don't want any movement that supports me to be harassing witnesses or harassing the victim's family. Because if she said it, they would listen to her. But she's never once called off the dogs.
So the court can contrast the two. Thank you.
All right. Thank you. Mr. Leslie?
So here's Robert Alessi's big moment to shine. I'm just going to show some of this because it go like Robert Alessi always does. He always takes up way more time than he needs for his bombastic. You know what it's like listening to Robert Alessi? It's like one of those games on street corners, like a shell game, follow the ball game. And it's really, his arguments are meant to confuse and obstruct instead of shed light. Because you have to confuse the issue, because he couldn't argue this on the real facts that he has a expert witness here who is sticking to, for Do Re Mi, his debunked opinions. You can't. It's like science has moved on, but you're still going to stay, right? You're still arguing the earth is flat. Well, it's an opinion. It's not an opinion. It has to be an opinion based on modern, up-to-date science.
May it please the court.
Actually, you know what? Before I do this, let's get into your comments. I think we need a palate cleanser. At least I do. Lolly, I won't be showing much of Alessi's. Lolly77 says, Alessi loses me. Can't listen to his droning arguments. Now, Brennan, I can listen to for hours. He's great, right? He makes so much sense. Lally made sense too. He just wasn't camera friendly, show ready, presentation. I don't think he likes public speaking. I don't think he likes being the star of the show. I still think he would have proved his case. Like I've always told you before, when I was a juror, they made us swear as jurors that we wouldn't hold it against the jurors for not being like lawyers that we see on TV, meaning TV shows, entertaining, meaning these court cases are not supposed to be entertaining. Sometimes they are. But I'm thankful that someone a little bit more theatrical and camera, I don't know, a little bit more theatrical. How would you say it? A little bit more succinct. I just thought Lally's opening statement was way, way too long. Try to bring in every bit of evidence into the case that you're going to show. It's really just like a trailer for a movie. Here's what this movie is about. You want to see it or you don't. Here's who's in it. Here's the feel of it. Okay, let's get into your comments.
We got your comments. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
Okay. Comments. Let's get into it. There's one with like a typo. I'm not exactly sure where it's going, but the Pabs 0605 says, how Karen Reed and her family can sit there trying to blame a young teenager and then two women who were friends with John O'Keefe, and yet she was the only one who was fighting with him and also the only one who stated, did I hit him? She's the only one who stated, I hit him. I hit him. It's my fault, which is even more telling. It's like the O.J. Simpson case, part 2. Once the defense team gets involved, they distort the truth. Shame on them. I agree. Maybe I need to go over that David McKenzie interview, that part again. Holistic psychology, where he says, like, you can't lie, cheat, and steal as a defense attorney. I have no problem putting on a vigorous defense with it, but you can't go out the realms of reality, basically. Holistic psychology says the best part of today, meaning the hearing, was when Alan Jackson said he files motion to dismiss the whole case, but has until this day absolutely no legal grounds yet. So glad you brought that up, holistic psychology. Alan Jackson and David Yannetti seem to be cruising and giving the heavy lifting to Robert Alessi. And whether this was done because of money issues, that they said they needed more money for all these hearings, and that the retainer for the second trial just covers the trial and not these hearings. I have no idea. But it looks like Robert Alessi is doing all the work, and he came across as a kid who hadn't done his homework yet. Alan Jackson did. Didn't he? Well, I haven't looked at it. We'll be on time. He seemed to have done no work, but promises that he'll have it done within the time frame, because Cannoni is pushing everything forward because the trial starts April 1st, April Fool's Day, appropriately. This guy, Alan Jackson, is such a pathetic tool. So this is where I don't understand. Hold on. I took law school in criminology, and the legal community sees how embarrassing it is. I think that's what you mean. I had law in school and took criminology. I don't know. And the legal community sees how embarrassing he is. I don't think he will ever be invited to elite gatherings again. I don't know. They all seem to They don't seem to shun one another, these lawyers. They all seem to be in the same club. Cat in the Shadows says Karen Reed needs a vacation to the Bermuda Triangle. Oh my God, that stupid raffle. What a joke. I believe that, or that stupid ass raffle. What a joke. I believe that photo needs to be sent to the court. The photo of AJ and her canoodling. That is not freaking okay. Exactly. When is it okay to have an affair with your client as a lawyer and canoodle out in public when you're a married lawyer? When is that okay? Ugh, that's so gross. What's more offensive is that they say they have, Yannetti said he had proof that the taillight was in a different condition than when Karen Reed gave it over to the cops, than when it was shown as evidence. I mean, that we've never seen any evidence of that. We've never seen any evidence of Karen Reed's brain tumor that Yannetti told the court she has. Who are these clowns? Karen Reed is factually innocent. Do you think if you say it enough, you'll make it true? Do you think you'll wish it into existence? Free Karen Readers?
He is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search of House Long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without...
He should have. And I'm surprised Brennan really didn't go after his qualifications. It's more like you really can't be using debunked science, but I guess the whole objection to having him as a goes against his qualifications. But here he brings up Canoni, he appeals to her ego. You already accepted it in the first trial. You really want to admit that he wasn't qualified?
Objections to his methodology. Your Honor sat obviously and presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection.
But they are being challenged now.
I was just waiting, Your Honor. Mm-hmm. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detailed than what happened in the first trial.
It's more detailed because I wrote it for him. I think all these lawyers should be brought up in front of the bar. They're all going beyond the rules of their profession. You can't rewrite. You can't rewrite your expert witnesses' opinions and submit them.
In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr.
He just relies on his wrong reading. On his wrong reading. The wrong reading that, and he keeps going with it. Once he's been told he's wrong and they have to rewrite the program because he's wrong, then he just doubles down on his wrong opinion. That's his methodology, Your Honor.
Brennan challenges the methodology. None of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a...
Everyone agrees it's the artifact. Everyone agrees. There was actually a search at 623 and 624. It's only our McNasty Green, our criminal, money-hungry strip mall expert, who says it. Why can't he testify? Sure, they had to rewrite the program because he's wrong. Come on, let him confuse a juror or 2 with this debunked wrong opinion. Why not?
Full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint, that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute.
It's remarkable there's even an issue. Can you believe it, guys? Can you believe there's an issue with this expert? This expert witness? Can you believe it? Who would have thought that they had a problem bringing this guy up with an opinion? I can't. Anyway, it doesn't look like there's going to be a hearing. For those that missed this hearing, it doesn't look like there's going to be a hearing, unfortunately, because it would be great. It would be like a little pre-trial snack to see McNasty Green up there and Ian Whitfin and Jessica Hyde. Although I don't think Jessica Hyde, I hear that she might not be testifying for trial, but I don't know how dependable that's just a rumor, if that's actually fact. I can imagine that Hank Brennan is going to be, I can imagine that he will be paring down the state's case. It was awfully long, 8 weeks, the Commonwealth's case. I can imagine him paring it down a bit. So I wouldn't be surprised if just Ian Whiffen testifies and not Jessica Hyde. But that would have been fun. But apparently it seems like Cannoni has enough to rule on. They're moving forward. We've got more hearings coming up in the coming weeks. And then she talked about jurors and trying to get as many jurors as possible at the end of this hearing. So I guess everyone recognizes from the previous trial that there was a hung jury. And I love the people that say, the free Karen readers that say, ha ha, it was a hung jury. She'll never be convicted. You may be right. They may try again. Sometimes they have to do 3 or 4 trials before someone gets convicted. But usually the second trial, let's look at Adnan Syed had a second trial, was convicted. Rabbi Newlander had a second trial, was convicted. Goes on and on and on. Where you get hung juries. Menendez brothers got a second trial and were convicted. So it goes on and on and on. That's where I'm going to leave it for today, guys. I'll be back tomorrow at 6 p.m. Eastern. Have a terrific night, everybody. I'm going to go out the way I usually go out with my hit song, I Hit My Boyfriend with My Car. Have a great night, everybody. Oh, let me pull this out. Wait, hold on. Let me pull this out before I go out. Have a great night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen. on your word, mama. My innocence fraud campaign is my biggest hit yet.